Not much was covered about the last hearing that was actually posted for the public because much of the narrative beneath the surface of this meeting was the judge seemingly starting to favor prosecution's side on all things. However, particularly interesting is that much of the media has spun this as a win for Bryan Kohberger, even though it absolutely was not. Mainstream media overlooks the subtle victories of prosecuting attorneys and sometimes even embellishes them as a defense's overall win. Much of the fine print is just overlooked in the judge's overall statement, a long report that he put out about the IGG information in general. One such overlooked detail is the fact that the prosecuting attorney in this case was granted the first known protective order in a criminal case to protect an informant. Here's the twist: this informant wasn't aware they had been an informant. They were an unintentional informant, a genetic relative in the DNA family of Bryan Kohberger, allegedly. This overlooked detail not only suggests a unique aspect of this case, but raises questions about the roles and responsibilities of genetic relatives and their place in the court, and especially in an Idaho court, as apparently an informant. It's another layer of complexity that the narrative that broadly blames this on Ann Taylor and raises objections to Ann Taylor getting an index of the in-camera review. An in-camera review is an in-chambers review which is going to be held in private with Judge John Judge, and Ann Taylor raised no objections to the in-camera review, and she also didn't fight much even for the index that she had asked for. We've seen no objections there yet about the protective order, and this protective order was actually received under the pretext that she might bring up potential alternative suspects, which, as we know from earlier, Idaho has this weird rule that you can't even bring up alternative alibis, which would include alternative suspects, without first notifying prosecuting attorneys, and within a certain, which, that's the case with every criminal case, but in Idaho the particular is that you had to do it by a certain date or not even bring that information. And back to any old average criminal case, you have to have more validity than just, hey, I want to bring up some random ass name from the IGG investigation. There has to be some viable connection, some validity, such as we've seen famously in the Casey Anthony versus Florida, that we hear Ann raise no real objections and doesn't fight terribly hard for that index either.
I'm going to request that the court make a privilege log of what the court receives in this packet of information the court's going to review. I will want that to be released to me to make sure the court has a full packet of information to review in making its decision.
Counsel means by a privilege log seems to me to defeat the purpose of the in-camera review if the court tells the defense everything that it received. I mean, that seems contrary, so I don't know what's being contemplated.
I interpreted that as that the state needs to document everything that they're getting just in case, so that if there is an issue down the line, that is documented. That doesn't necessarily mean that you turn that over to the defense automatically. So I don't know if Ms. Taylor suggested that you provide all that information to Ms. Taylor before I make a decision in camera.
Okay, let's run that back.
I will want that to be released to me.
And we hear John Judge playing dumb. Neither of them understand what it is that she's asking for.
IGG procedures are not documented. There might be some notes. I understand that the FBI has some notes.
Another contentious point where the judge takes up her bill. Oh yeah. judge. So they basically claimed that there'd be no credibility whatsoever by Ann Taylor for any potential involvement for these IGG so-called informants. And the use of an in-camera review, particularly for something as crucial as S&P profiles that were used to generate the lead against a suspect, raises questions about transparency and the whole Idaho legal process. It's quite peculiar, and it's obviously a relatively new concept in legal proceedings. But traditionally, if they had used the quote-unquote informants that had actually offered up their information, in other words, had opted into the law enforcement portal for investigative genealogy work, they should just be able to use those relatives' names and it not be that big of a deal, but no. The prosecuting attorney wanted protective orders not just to protect these IGG so-called family members, but also to protect the third-party companies and people opting in instead of deciding to not let law enforcement use their genetic materials in their investigations anymore. And as soon as you think that's bullshit, actually, the company that acquired GED Match actually put out a statement within one of the coinciding months, so totally relevant to the BK case, after a bunch of that GED Match backdoor Vargas testimony was subject to the public's ears. We get that company statement dropping a public message about how it supposedly fixed the backdoor to the DNA law enforcement portal, but the backdoor that it won't fix is being able to create a John Doe profile under a normal user, and then therefore using the user side of the database, which is much more populated than the law enforcement's portal side. Now, notably, as was pointed out by experts, defense put on the stand they would have a receipt for this had they used the law enforcement portal. None of this has been turned over to defense. We've assumed all along that they've most probably used a user database rather than a law enforcement one. If nothing else, well, we have the company talking about the back door, so maybe they didn't need to do that, or they did both. Shocking, I know. The procedure of touch DNA inherently introduces a measure of doubt from the outset. Since touch DNA is left behind for merely touching an object, it can potentially implicate individuals who weren't present at the crime scene or even near the crime scene when it occurred. It's certainly less of an implication than, say, if your blood, saliva, semen comes up at the crime scene. Well, I don't have much reason to doubt that you were at least there. Doesn't mean you committed the murders? No. But you were certainly there and probably most likely there close to it happening. Touch DNA is a horse of a different color. And while it provides investigators with additional leads, it also necessitates careful analysis, corroboration, and typically other forms of evidence in order for the case to prove crucial forensics, implicating an otherwise innocent individual, especially one with no connection to the victims. And it's kind of ironic, I don't know, it just blows my mind sometimes that the public has so decided that BK is guilty. And I mean, the types of evidence that they have against him are being argued in the last 10 years to be a pseudoscience, such as the cast, and then touch DNA, originally referred to in the forensic world as trace DNA, which is involved in the last 10 years significantly, but in its early stages, it was not even direct evidence in a crime due to its minimal and obscure nature. Of course, with advancements in science and technology, it can become an increasingly viable tool depending on critical circumstances and the investigation, of course. So, it's definitely revolutionized, but it's still not infallible and has a lot of limitations that other types of DNA don't have. It's more susceptible to contamination, to getting multiple profiles in one mixture, degradation, and the sample sizes are just insanely smaller. In one study in 2006, it was discovered that 51 to 70% of individuals failed to leave behind their DNA on a sterile tube that had been held for at least 10 seconds. In another study, swab cell phones, the one freaking thing that you think is definitely going to have your DNA profile, only in 1/3 of the devices was a profile found at all. In 28% of those, it was a partial profile. And in another 1/3, another individual's DNA had also been detected. So that goes to show you on its face, it's quite a complicated form of DNA. Even your cell phone's not likely to have your DNA, and if it does, it probably has someone else's on it too. And here's another twist. According to the experts hired hired by defense here, she calls Kohberger's profile partial and ambiguous. She also cites a case that is interpreting mixed DNA profiles. Now, one could assume that she is connecting that to this case to state all three, mixed profiles and partial and ambiguous DNA profiles, are less than perfect, a pain to analyze, and trying to read a book with the pages half torn out. But we can definitely see from the use of language that certainly she is talking about Bryan's case with the partial and ambiguous points of the DNA profiles. So now you take a partial profile, and to fill in blanks, scientists use a method called PCR. I talked about this in my DNA episode. This is like making thousands, actually millions and millions of copies. So you remember that lesson that we were taught where it's like when you make a copy of a copy, each copy is getting shittier and shittier and shittier. Eventually, you have a little busted up, crappy version of the original. So we are talking about that same thing happening with DNA in the PCR process. So we're talking about the judge's ultimate ruling that Anne doesn't get to see an index, or maybe she will, we'll see. But either way, she doesn't get to see the IgG and a lot of the alternatives. And the million-dollar question is, will we ever know how reliable the method was and the people that the FBI shut out of the possible suspect pool? So different scholars for the past 10 years and different legal cases have been bringing up the reliability of the cast team special agents hired by the FBI in order to interpret cell phone historical data. The FBI terms this a dedicated group of experts who meticulously analyze cell phone data. Yet the moniker belies the reality that despite their expertise and so-called precision, their work involves an educated conjecture, and the exact location data derived from cell phone towers is an artful estimation. And it is less than an absolute certainty. Yet again, buzz in the legal world, the chatter says that this is going to be struck as junk data. And even recently in a case, it got thrown out because cast investigators failed to be able to actually track a car during an experiment conducted by defense. Yes, you heard that right. This method is already facing some heat, and doubts have been creeping about for a while. Cellular Analysis Survey Team. Alright, so it sounds kind of technical, right? But really, Analysis Survey Team, the name itself is an approximation to the best guess of something. And interpreting cell phone data and attempting to pinpoint locations is arduous as it's not just about understanding technology. It can actually demand the grasp of physics that delves into intricate behavior of radio waves and their propagation. Not only that, but how that propagation interacts with various obstacles. And even a solid understanding of these principles delegates the understanding that these principles are not concrete and that they change and are fraught with uncertainties, such as being next to a river when you're connected to the cell phone tower. How many buildings are there? What is the weather like? While on a bridge, you could be connected to cells way further away due to the way that the energy bounces off of the water. So in the middle of a bustling city, smartphone in your hand totally depends on things such as the closest cell phone tower, how much actual signal you're able to get from which tower, what's the weather like, how many buildings, is there water, are there tons of people on during that time, during that signal, and how close are they to the tower? These things can be hampered by repairs, maintenance, and if they were all playing in a big orchestra, maintenance can definitely the rhythm. Meanwhile, what I say, weather, topography, population, density, did you like that song after all? Then you have to consider too whether you were indoors, outdoors. That's akin to figuring out how far you are from the concert hall through someone else's telephone. All these factors create a unique symphony, and you can listen to them, but certainly people are going to have different ideas about the proximity of the signal. The variability is so great that two identical phones on the same network have been shown to be in the exact location, could place calls at the exact time, and end up connecting to two completely different towers. Fascinating and complex world, and often sadly being silently paraded as an exact science or a little diary where they can keep records of all your pinpointed locations. But in reality, it's pretty limited. Because the main purpose of a lot of these records kept by the phone companies isn't to track your whereabouts, but to help phone companies with things like billing and working out their own charges with other carriers. They're not really for pinpointing you, and therefore, well, they suck at it. It certainly ain't GPS. That's with regular CDRs. Then you get into the CSLI, which is cell site location information. There's a catch. No one knows how accurate this information is for each and every company. Neither the phone companies nor the Federal Communications Commission have provided any clear data on error rates or how reliable the methods are. So while it can provide an idea of someone's location, it's not a foolproof system, and there's no clear error rate to even predict that it was or how close to it is. Does that even make sense? A lot of the protocols for deciding how and where these cell phone towers pick up is actual, I kid you not, homeboy in the van going around and asking everyone, like, can you hear me now? You guys remember the commercials for Verizon where he was gonna kill the guy out at the docks and he's like, yo, you get signal out here? Yeah, that guy. I'm just kidding, not him. But you know, the can you hear me now, bro? Yeah, that guy. But as it turns out, there are actually CSI effect studies that have been made by this. CSI effect studies are normally cited by prosecutors who feel that it creates a higher standard of evidence for conviction. But it's also believed to make juries likely to convict based on misunderstanding of forensic methods and experts that explain those methods as foolproof. The over-evaluation of this evidence was a concern in Denmark when the inaccuracies of cell phone location evidence were discovered. Before the scandal, cell phone location evidence was seen as highly accurate and often given a significant weight in courtrooms. The potential prejudice and confusion caused by unreliable cell phone location led to significant changes in the kind of evidence that is used there. In the United States, though, we still have this inherent risk of injury in placing too much weight on the cell phone location evidence, especially historical CSLI evidence, that is, the historical cell site location, accuracy, and how often it is overstated and supposedly objective evidence is actually produced by the prosecution. Such was the case with bite mark evidence that's now considered junk science. But when it was being used, the juries really resonated with it. They thought that it was something that they could physically see. They didn't need an expert to explain it to them. But as it turns out, they were really comparing bruises with what should have been a more comparative data set, such as actual teeth molding. Turns out skin is a terrible indentation marker for teeth, and what's left over is often a bruise on a deceased body and not an actual comparison scale to be compared with a model of someone's teeth. But as I said, juries felt like they could resonate with actually linked to the defendant and against the defendant, and much as cell phone historical analysis and touch trace evidence against this defendant. The death penalty rules in places like Idaho are tricky. On one side, these rules make sure that lawyers who know their stuff handle these serious cases. But on the flip side, these rules can make it tough for lawyers in other states or groups who want to help for free or pro bono to be able to do so. It makes it near impossible for anyone to step in and actually aid a hand. So I think that is actually an unhealthy perception, and something that I kind of wanted to point out is a catch-22. Rules that were made so a defendant gets a good attorney, but also could stop them from receiving help outside of the state. In Idaho, regulations known as the Idaho Administrative Code provide specific details on how these laws are implemented and enforced. For defense counsel in Idaho, one important part of this is the Idaho Administrative Code, which outlines requirements and procedures for representing indigent persons. This code sets the standard and procedures for attorneys who represent individuals who can't afford their own lawyer. One specific part of this code is the requirement for a specific raw roster of attorneys who are qualified to represent defendants in capital cases. But here's the thing. There are really specific guidelines, such as having experience with Idaho law specifically, and maintaining a curriculum that's Idaho specific as well. The Public Defense Commission in Idaho maintains this roster. Attorneys have a set of rules, and governing bodies like Idaho Association of Counties manages the funds for Capital Crimes Defense Fund. This is where we see potential conflicts, such as Bill Thompson being a part of this board at the Idaho Association of Counties, which pays for Capital Crimes Defense Fund, or makes decisions about and pays this very tiny small pool of qualified attorneys. Obviously, any small pool of attorneys brings up the question of impartiality. There also seems to be no immediate watchdog or ethical oversight. There seems to be no public records pertaining to why Anne, above or besides anyone else on the roster, was assigned to BK's case. Certainly, they can't just assign a death penalty eligible attorney for every case that's eligible, because Idaho has a quite broad law regarding the death penalty, and it's pretty wide-ranging. A lot of serious violent crimes could potentially lead to the death penalty. So that gets even more confusing, because there's just a small group of specialized attorneys who are supposed to handle all cases that are eligible, or what? I don't know, but it's yet another looming question about Idaho. Alright, so all of these confusions revolve around a guy who was once a diligent student, pursuing degrees, becoming a specialist, applying to the local Pullman Police Department, offering his hope in aiding small police departments, and then during this inaugural semester at WSU, the narrative takes a turn for the worse, and the dude just somehow says, you know what, master's degree be damned, psychology and all that jazz. He's gonna murder 4 students who he allegedly has no connection to, according to his defense attorney. And many of us ask why. Why would you cross the state lines and murder where the consequences are possibly going to be death when you're already living in a state who has canceled the death penalty, abolished it, gone, no death penalty to worry about? For others, it's just puzzling why the murderer left behind his own knife sheath, especially one that's made for the military. It's made to go into war and still remain on your body. So he completely exits the premises unsheathed. Many say, oh, he was startled, he had to run out. But for many, this discrepancy just further contradicts the narrative. The knife ninja, despite a bunch of clumsy actions, leaving his car outside, the 3-point turn. Well, actually, I guess the 3-point turn could happen to anyone. But some guy who they allege is this big bad murderer didn't seem very sensible in the moment. And I know people say, okay, well, you can read about football all you want, but will you actually be able to play on the field? But the thing is that it's in stark contrast to what happens outdoors. So outdoors, he's circling the house, he's making 3-point turns, and then all of a sudden he makes a swift entry from exit to third floor, second floor. There's this 10-minute time frame. He murks everyone, and it's as if we're dealing with two individuals. The bumbling car ninja outside, but the swift, highly efficient ninja inside. Some people claim it's nothing, but for others, it's just another incongruity. In the land of innocent until the fat lady sings, we'll consider the case of an out-of-state student who was the perfect scapegoat when a university was grappling with an unsettling reality. Then the perfect solution, the stranger killing, a narrative that suggests danger can come from outside, and it can happen to any one of us. Some argue that blaming WSU via a student going there wouldn't serve the university's interest any better. However, if we consider it that if they could hypothetically close the case up with a bunch of Idaho University grads and lock WSU all the way out of it, they'd really have no say. So would it really matter? And doesn't it take a stark comparison? Does Idaho University really give a shit if WSU students dwindle? I'm not sure. But WSU has its own set of problems with the police force over there. I have other episodes that begin to cover this. But if everyone placed in the Idaho courts are also the Idaho University's grads, the dynamics kind of shift.
Your reaction to getting this news, was this a surprise, hearing that there's a date scheduled and it is December 28th?
Yeah, I was surprised that we're at a moment in the case that we don't even have a trial date. We've had a trial date for almost the vast majority once they had a suspect. So we don't have a trial date, but we have a date to have, largely the biggest piece of evidence being destroyed, which just seems backwards.
So I would have expected that something this monumental would have been discussed behind the scenes, that your lawyer, Shannon Gray, would have been in conversations at least to give you guys, enough time to process this.